Well, good. Well, thank you, everyone, for coming. My name is Christopher Katropia. I'm a law professor here at the University of Richmond School of Law, and welcome to the 5th annual Evil Twin Debate featuring Professor Daniel Crane from the University of Michigan and Professor Michael Carrier from Rutgers University School of Law at Camden. The Evil Twin Debate series was founded on this notion that there are experts out there that are at loggerheads over policy issues, but deep down inside, they're friendly with each other. And so we've picked two of these, I hope, right? Two individuals that we've made them sit next to each other. They can hug it out later, I guess. And so the idea is we would get these experts in to kind of have a good spirited discussion about a topical IP law kind of policy issue, but do it in a manner where it's a friendly exchange, right? Serious in substance, but lighthearted in tone. So if you guys didn't get that message before, I know exactly, sorry. And so today's is entitled Drug Settlements Patently Anti-Competitive. Right? Settlement's a good thing, right? You know, parties come together, they're friendly, amicable, we're not going to waste any of this money on these pesky attorneys or public resources on trial, right? Settlement's a good thing. Well, today we'll explore whether it really is or not a good thing, right? Many patent infringement suits between pharmaceutical manufacturers and generic drug makers have resulted in settlement. There's been questions as to whether these settlements are anti-competitive or not, or harmful to society or not. And that's the topic that'll be explored today, this idea of whether these are harmful things or not. And so what will happen here is after I get done with the remaining parts of the introduction, Mike will kind of go first. He'll provide a much better kind of foundation to the topic than I just did, and then kind of proceed into his kind of take on the issue. And then Dan will have 15 minutes to present his side, and then Mike gets to rebut for 3 minutes, and then we'll have some question and answer session, and then we'll adjourn to the foyer for some refreshments. Now, ever since the Evil Twins debate has been around, we've had a tradition. And the tradition is, and I think this is a tradition that most people have, right, is that we'll present the biographies of the two individuals that are presenting. But in true kind of Evil Twins fashion, we ask the other evil twin to write the biography for his or her, quote, opponent or friend. So Dan wrote a biography on Mike, and Mike wrote a biography on Dan. So first, Dan's biography on Mike. Despite being wrong most of the time, I guess that'll be today, too, probably, right? Michael Carrier has an impressive bio with few qualifications we'll have to mention. He received his undergraduate degree, embarrassingly, from a college whose name rhymes with jail. He then recovered and matriculated at the University of Michigan Law School. Inexplicably, it took him 3 years to get his JD, but he graduated magna cum laude and was an editor on the Law Review. Venturing forth into the real world, Michael landed a prestigious clerkship with the Honorable John D. Butzner, Jr. on the most distinguished of federal circuits, the Fourth Circuit. Yes, pandering is cheap. He then went to work at Covington and Burling in Washington, where he worked on antitrust and intellectual property matters and organized the earliest Occupy Big Pharma protest. Having found the real world... I thought it was funny. Having founded the real world dull, Michael returned to academia and became a distinguished professor at Rutgers, Camden. Since then, he has published many important books and journal articles in the most prestigious presses and law reviews. The two most important are his book on innovation for the 21st century, Harnessing the Power of Intellectual Property and Antitrust Law, and his best-selling monograph, Generic Medications for Southeast Asian Racing Camels, Breaking the Power of Branded Monopolies. Michael's works, probably including that last one, have been cited in many distinguished court decisions and also the Supreme Court of the United States. We could go on, but as we said at the beginning, Michael has an impressive bio. Okay, now Mike on Dan. There once was a man named Crane, was famous from plane to plane, started at Wheaton, sits now at UM, through UC, Cardozo, and almost Spain. He is writings galore. Think you're done, and there's more. Pangloss, Hot Oil, Modesty, Bad Soup. With titles like those, who's bored? Knows about settlements, yep, even with payments. Those things are dated and overrated, even if some make no sense. Crane's debating today, evil twins at play. We know what we're getting, we had the vetting, the man with Obama haberdashery. Okay, the last comment puts us into what hopefully will be a new tradition that these two individuals started, and that is when they arrived in Richmond, they did not have the ties that they have on today. These ties were purchased by their friendly opponents. So Dan bought Michael this beautiful tie here, and Michael bought Dan this beautiful tie here. So, with apparel on, biographies out, let the evil twin debate begin. Mike?
Thanks so much, Chris, for that introduction. Thank you, Dan, for the introduction as well. I've given many bios throughout the years, although this is the first time that the word jail has appeared in my bio. So I'm grateful for that, and maybe I'll use it on the Rutgers website. I really appreciate that. Also, thank you to Jim just for the invitation and the whole idea of an evil twin debate. I think it's a fabulous idea. Many of us in academia tend to preach to the choir. We say stuff that we believe in and surround ourselves with people like that. And the chance to, in good humor, deal with opposing points of view, I think, is a fabulous idea. So what I'd like to do today is first give the background on drug patent settlements. Then I will give a little background on the Hatch-Waxman Act, why that is relevant. Then shifting gears a bit, putting on my evil twin hat, I'll talk about what courts do here and perhaps critique what courts do. Then I will mention a couple problems with these reverse payments and with the settlements in general, and finally some solutions. I know I only have about 15 to 16 minutes, so I'll talk quickly. So for starters, basically we have settlements. Now we have patent settlements in many areas of law, but in those areas of law, basically what happens is the patentee sues the infringer, and the infringer pays the patentee in order to enter the market. What happens here is different in that the patentee pays the infringer for the infringer not to enter the market. And so I'm sure Dan and I will talk about how important that is or not important that is, but just to get things started, that is a difference between other agreements and the agreements in the pharmaceutical setting. The reason for the complication is something called the Hatch-Waxman Act. For those of you who have difficulty sleeping at night, I would recommend not getting sleeping pills. Curl up with a copy of the Hatch-Waxman Act, because if you do that, you will fall asleep instantly. It is that complicated, that difficult to deal with, but nonetheless, Congress tried to solve all of these problems in the pharmaceutical industry by passing the Hatch-Waxman Act. It tried to do two things. First, it tried to promote brand firm innovation. At the time of the act, there was a real fear that there was an innovation crisis, an R&D crisis. The patent term that was effective had fallen from 17 to 7 years, so there was a real worry about a lack of brand firm innovation. On the other hand, there was a real worry about a lack of generic competition. There were 150 drugs who had gone off patent, but nonetheless did not have any generic on the market. And so you'd have the end of the patent term, but still the brand company continuing its monopoly because there were no generics around. And so that's how we wind up with the Hatch-Waxman Act. In 1984, Congress passes the Hatch-Waxman Act, and they include several provisions in the act designed to deal with these two main problems. The first problem, again, was a lack of brand firm innovation. And so what Congress did was they created three mechanisms that were designed to promote brand firm innovation. The first was an extension of the patent term that would extend the patent life. The second was non-patent market exclusivity. So you get exclusivity not just from the patent, but also from the FDA. If, for example, you're the first to come up with a certain active ingredient, then you'll have a period on the market in which no one else will be there. Finally, they provided for an automatic 30-month stay of FDA approval. And so these three mechanisms were designed to promote brand firm innovation. On the other side, what they tried to do for generic competition, again, were three main things. The first was something called an ANDA, an abbreviated new drug application, that allowed the generic to piggyback on the brand firm's clinical studies, which are very expensive, take a long time. So if the generic could show that it really was equivalent to the brand drug, then it could rely on its application. Second was an experimental use defense that said that it was okay for a generic to experiment on the brand firm's patent during the term of the patent. And that led to generics entering the market as soon as the patent term was over, because you could experiment during the term rather than waiting until the term was over and then taking a few years after that point. And finally, and most relevant for our purposes, they gave a 180-day period of marketing exclusivity to the first generic that challenged the brand firm's patent, claiming that the patent was invalid or not infringed. And there are several certain paragraph certifications that you can make. It's a bit complicated here, but basically what the brand firm does is it files a new drug application with the FDA. At that point, the generic has to certify something if it wants to enter the market. And so there are 4 potential paragraphs, and 3 of them aren't relevant for our purposes. Those mean that there's no patent, the patent has expired, or the patent's going to expire. The 4th one is the key. It's known as a paragraph 4 certification. And in that certification, Congress really wanted to push it, because in this certification, the generic is saying, we really think the patent is invalid, and we're going to promote that by giving 180 days to the first paragraph for generic, because we want to get these challenges to patents as quickly as possible. So in a nutshell, that's what the Hatch-Waxman Act is about. It's very complicated, and that 180-day period in particular has led to a bunch of the problems that I will talk about. The next point is what courts have done. Courts have decided these cases by relying on, as I see it, 5 general principles. Now, the courts that have done it recently have all upheld this sort of behavior. And when you look at the reasons why they uphold the behavior, it falls into 5 categories. The first is that this is a settlement, and a settlement is good. Settlements are good because they save time and money, they relieve courts of their burden of dealing with these cases, and so in this case, it's a settlement. We know settlements are good, therefore this is good. So now if I can shift a bit and start to put on my evil twin hat, I would say, well, sure, settlements are good in theory, but that doesn't mean all settlements are good. And in particular, in this context, when the settlement disposes of the very challenge to validity that was the whole point of Hatch-Waxman, that's why they gave 180 days to the first to challenge the patent seeking to enter before the end of the patent term, then it doesn't mean that settlements in this context necessarily are good. Second, and relatedly, settlements promote innovation. If the drug companies could settle their cases, then they'd spend less time in court and more time innovating. You see that littered throughout the cases. But again, I would say that not all the settlements are good, and there are many, many mechanisms in Hatch-Waxman, I talked about them already, that are designed to promote innovation. There is no discussion whatsoever that settlements were designed to promote innovation. The third point is that patents are presumed to be valid. So in these cases, we don't know if the patent is valid or not, but there's a procedural presumption in the Patent Act that says that patents are presumed to be valid, so therefore we will assume that these patents are valid. Again, I would have some criticisms of that. Just because there's a procedural presumption as to who has the burden first doesn't mean that that gives us substantive evidence of what the validity is. In addition, there are challenges that are central to the Act that are blocked when you just assume that these patents are valid. And finally, not every patent that's ever been issued is valid. There are studies that show that at least 45% of patents that are issued are invalid, and so I would not rely on this procedural presumption to decide the substantive evidence of whether or not the patent is valid. The fourth point is one that, in a sense, I think is the strongest one, and for me is the most frustrating because no one has really focused on the flaw in the argument. So the fourth argument the courts offer is that these agreements fall within the scope of the patent. The agreement tells the generic, go leave the market, I'll pay you money, but it's about the patent at issue. It falls within the scope. And the reasoning is, if I have a patent, I have the right to exclude competitors, so therefore I can do the lesser action of paying you not to compete on that particular product. The frustration for me is that this entire scope argument assumes the very validity that we're trying to prove. If the patent is in fact valid, then yes, the brand company can pay the generic to stay off the market because the brand could rely on its patent to keep the generic off the market. If, in contrast, the patent is not valid, let's say it was not new or it was obtained only through fraud on the patent office, then in that case, the patentee is not allowed to pay 1 penny to the generic to keep it off the market. That's market division, but we don't figure that out by saying it's within the scope of the patent. And so that's a frustration for me, that when you say scope of the patent, you're assuming that it is valid. And finally, the courts say that these are natural agreements. It's the natural status of Hatch-Waxman to have these reverse payments. It happens all the time, so therefore it's okay. And I would quibble with that. Just because something happens all the time doesn't mean it's good. That's why we have something like antitrust law. Nonetheless, these are the 5 principles on which courts have recently relied in basically upholding all of these agreements. Let me now shift to what I view as some of the harms that are presented by these agreements. The first, in general, is antitrust harm that comes from market division. So like I talked about with scope, if you have an invalid patent, a patent that should not have been issued in the first place, and the patentee then takes that patent and says to the generic, don't enter the market, that's a form of market division because there's no valid patent at all. The patentee should not be able to do anything because it's not a legitimate patent. That's a real concern for the antitrust laws. The antitrust laws don't like market division because 2 companies, 2 rivals, are taking the market, dividing it up, not competing on any axis whatsoever, and so that's a real concern. Another difficulty here is that we can't really tell if the patent is valid. And so I've spent a lot of time saying, is the patent valid or not? Courts can't figure that out because they're in the middle of an antitrust case. That's a lot of documents, a lot of money. Are they really going to plop down in the middle of that antitrust case a complicated patent case that could have a claim construction hearing itself that could go for 2 weeks or more, patent infringement litigation that could go for a long time? So that ultimate determination of patent validity can't be undertaken in this setting. And so that's why some of us have shifted to reverse payments. They're known as reverse payments, again, because the money goes the opposite way than it usually does in settlements. But the concern with this payment is that it allows the patentee to get more protection than it otherwise would. So let's say there are 10 years left in the patent term, and the parties will agree that there's a 60% likelihood that the patent is valid. If that's the case, then for the next 6 years, the patent should be operative, and the 2 parties could agree with no payment whatsoever that the generic could enter in 6 years. I think that's fine. The problem then becomes, what about when the brand pays the generic an extra $100 or $200 million and then gets an extra 3 years of exclusivity? So now the generic is going to enter in 9 years rather than 6 years. That's not based on the strength of the patent. It's based on the strength of the patent plus this extra payment. And so that's the concern with these reverse payments. The patentee is getting more protection than it deserves based on the strength of the patent alone. And I think one final point here involves the incentives of the parties. In many cases, let's say we're just dividing up the market in terms of time, the brand and the generic have different incentives. Here, in contrast, the parties have the same incentives. The brand would make so much in monopoly profits from extending that, even for a day or a couple days, that it could take a small subset of these profits and pay the generics. It still does really well, even if it pays $100 million, drop in the bucket for $1 billion drug, and the generic then takes this money and pockets it. And the generic actually could make more money from settling the case than it could have from winning the case and from entering the market. And so notice here, both the brand and the settling generic have incentives that are aligned and incentives that work against the interest of consumers in many of these cases. So in my final part, I'll talk about some potential solutions. The courts, I'm not sure how much leeway that they will give for any challenges. It seems like there's a real momentum in the last several years to say that all of these agreements are good. So let me focus on a couple possibilities that have been proposed in Congress. The first has gotten the most attention. It's been introduced in each of the past several sessions of Congress, and it's basically either a per se violation or some sort of presumptive illegality whenever there's a payment for a delay. So the legislation typically says we're going to prohibit agreements by which the generic receives, quote, anything of value, close quote. So it's anything of value. It's not just payment. It's anything like a payment for an unrelated product in exchange for the generic agreeing to limit or forego research, developing, manufacturing, or anything else related to the product. So again, the two key elements here are the payment and the delay in entering the market. The House of Representatives initially offered a per se illegality rule. That has seemed to have been replaced with a rule of presumptive illegality, which is where we stand now. Again, every January or February this is introduced. Sometimes it gets further than others, but that is one potential possibility. Another possibility that hasn't gotten as much attention, but one which I think could be even stronger, would target the 180-day period itself. And so Senator Nelson offered this a couple years ago. Senator Bingaman offered one just this week, in which we open up that 180-day period. The problem now is that the 180-day period is reserved for one company, the first generic to file a paragraph 4 certification and challenge the patent. So if you have only one company that you have to buy off as the brand company, then that generic is sitting very well, sitting very high, and there's no one else that can enter the market. So the 180 days is not even triggered until commercial marketing from that generic that just agreed that they're not going to enter the market for the next 10 years. And so the 180 days really is a bottleneck. And so what this legislation would do is it would open up that 180-day period. Yes, the first paragraph 4 filer is included there, but so also is the first party that wins in district court, showing that the patent is invalid or not infringed, as well as parties that are not sued. So if you open up the 180-day period to all of those groups and say whoever markets first gets to get that 180 days running and then everyone else can enter, but at least the 180 days has started and there's a generic on the market, then all of a sudden we have avoided the huge bottleneck presented by Hatch-Waxman of the 180-day period. And so that's where we stand now. I'm not waiting by the phone, waiting for the call that Congress had passed this legislation. It's introduced a lot. Sometimes we get hearings, but it's very hard to get anything out of Congress when the brands and the large generics are basically on the same side saying these agreements are great. So in conclusion, I am sure my evil twin will rebut everything that I said, but nonetheless, I think that there are really some concerns with these sorts of agreements, and I look forward to debating them more. Thank you.
Well, it's a real delight to be here. Thank you to Chris for the introduction. Thanks for Jim for the invitation. Thank you to Mike for a provocative, cogent, clear, robust, and of course, erroneous beginning to this topic. So Michael and I have been, and others have been debating this topic for the better part of a decade. It's maybe the most overwritten topic in antitrust law in the last 10 years. Last summer, shortly after I got the invitation to come here, I was driving from Albuquerque, New Mexico to Santa Fe, sort of thinking about what I might say, thinking about this issue. And I kept thinking, you know, Michael is such a smart, well-informed, and well-intentioned guy. How can he be so wrong persistently? I mean, why haven't I persuaded him yet? And then I started worrying that maybe he wasn't wrong and that I was wrong, but you know, I'm smart and well-informed and well-intentioned too, so what's going on here? And then as I was sort of surveying the ancient wilderness landscape, it occurred to me that Michael and I might not just be antagonists over some little niggling policy debate about drug policy, but maybe we are sort of archetypes in the epic story of humanity. Maybe we were sort of predestined to play archetypal roles that have been played out since our ancestors separated from the Neanderthals, and will play out again until we're all destroyed by an asteroid. And so then I started thinking, well, if that's true, so what are these archetypes? How should I frame them? And then suddenly my boys called out from the back seat, "Daddy, look at the forest fires." And I looked out there, and this summer there were some really devastating forest fires in New Mexico. And sure enough, there they were. So I started thinking about fires and archetypes, and who do you think about? Of course, Prometheus. So, for those of you who don't remember your Greek mythology, Prometheus was the Titan who, in Greek mythology, stole fire from Mount Olympus, brought it down to the mortals. Zeus condemned him to the worst punishment that one can imagine, treble damages and attorney's fees. Actually, no, it's worse than that. An eagle got to pluck his liver every day, and the liver grew back. The next day, the eagle again. By the way, the tie Michael is wearing is a replica of Rubens's portrait of Prometheus Bound. So anyway, so my thoughts then turned to this question of archetypes and Prometheus, and suddenly it came to me. And here's the vision I had. Michael and I are cavemen. We're sitting in a freezing cold night during the Stone Age, bundled up in our furs in a cave, and suddenly Prometheus walks in and offers us fire. And I fall down on my knees, prostrate, and say, thank you, you've changed my life, you've changed humanity. And Michael barks out at him, "You wretched thief, I'm reporting you to the gods." So with this realization, I sort of understood Michael and myself as sort of two different archetypes of humanity when it comes to questions of innovation and norm compliance. And sort of my perspective here being that I value, in some sense, innovation above all else, even if it means stealing, plundering, and defying the gods. Michael, I think, is arguing for order and norm compliance. To put it in sort of more economic terms, I'm arguing for dynamic efficiency. Michael's arguing here for a vision of static efficiency. And those sort of prior attitudes or beliefs take us in really different directions on this question of patent settlements. So the distinction, I think, really comes out in the way in which Michael has framed today's debate, which is about price competition, right? The virtue of generic entry is that prices fall, and the evil of these settlements is that generics won't come in as soon, and so prices stay higher. In my view, though, the big picture question that we have to keep in our background thought is, what are the policy levers or drivers that will keep up the flow of pharmaceutical innovation? During the last few decades, we've seen a tremendous slowing in the pace of pioneer drug applications or pioneer drugs coming to market. According to the NIH, the pace of new drug introductions has slowed dramatically in the last 15 years. Companies are failing to pursue promising leads for drugs that will deal with maladies like depression and Parkinson's disease. Just one statistic, in 2004, 57% of all prescriptions were generic. In 2009, the number had risen to 75%. Now, from a static efficiency perspective, that's a great thing, right? Drugs are cheaper. People are accessing drugs that are generic. But consider one implication. Part of the reason that we're seeing such a huge shift towards generics and away from branded drugs is that we're seeing fewer and fewer blockbuster drugs coming onto market as the old blockbuster drugs are going off patent. Recently, the Obama administration announced that it was so concerned about the lethargic pace of new drug applications that it was committing $1 billion to a new drug development center. So we have a real problem in the background with a slowing pace of pharmaceutical innovation, new blockbuster drugs. Now, that does not mean that we should suspend all of our usual antitrust rules and allow pioneer drug companies to do whatever they want, no matter how anti-competitive. But if we're thinking about forest and trees, it seems to me that the trees here is the prices, and the forest here, the big picture, has to be innovation policy and what policy levers will incentivize firms to come out with more drugs, new drugs. So now I want to focus on the specific question that Michael has had us think about, which is branded generic settlements and their implications for static efficiency and price competition. Let me suggest at the outset that I think this focus on reverse payment settlements is fundamentally misguided and misconceived. As Michael has said, a number of commentators and some courts have said there's got to be something funny about this. Ordinarily, a settlement involves a plaintiff suing a defendant, paying the plaintiff to go away effectively, and here it's the other way around, it's the plaintiff paying the defendant. But of course, that is a straightforward and unavoidable consequence of patent law and the Hatch-Waxman Act. There is no consideration that should flow from a generic to a branded firm because there is no damages yet incurred. The generics have not yet entered the market, right? So this is not going to, whatever the settlement is going to be, it's not going to look like an ordinary settlement where a defendant pays a plaintiff some discount on the plaintiff's damages claim. As Michael noted, for 30 months there is an automatic stay provision of the generic's ability to enter the market, which means that in most cases there simply will not be any damages at all that can be the basis for the settlement. So what kinds of motivations would the branded have to settle with the generic apart from sort of market division? Well, there are obviously many. One is simply avoiding the direct and indirect costs of litigation. Most commentators have focused on sort of attorney's fees as the obvious cost of litigation. There are many, many others. Sort of for every dollar spent litigating a case paid to attorneys, there's a huge amount of drain on managerial time and resources, turning over sensitive documents and discovery and so forth. Secondly, many of these settlements have features apart from simply an agreement by the generic not to enter. For example, the transfer of some patent portfolio from the generic to the branded firm often accounts for some of the consideration in the case. And of course, it's true that one of the things that the branded firms get from the settlements is the elimination of risk and uncertainty. Now, I think Michael would think that the elimination of the risk here can't count as something good because the risk to the branded firm is simply the probability that there will be generic entry, which is good for the consumer, so the risk to the branded firm is sort of benefit to the consumers. But observe that that's even true in a case with very low probability that the branded firm will not win the case. Say a 5% probability that the generic will actually win the case still translates into a very large uncertainty that the manufacturer, the branded firm, is willing to pay to eliminate. This brings me to the sort of the central point about reverse payments, which is that when a branded and generic firm settle in a way that leads to later generic entry than otherwise might have happened, the social cost calculation is not driven by the fact of a reverse payment. The social cost calculation is the following. It's the but-for probability that there would have been earlier generic entry times the deadweight losses from overpricing by the branded firm during the period when the generic doesn't enter. So the key driver in that equation is not the direction in which the payment flows. The key driver in that equation is the probability that the branded firm will not, in fact, win that litigation. And the direction in which the payment flows is at best one piece of evidence, which sometimes very weakly points in the direction of probability or not probability that the branded firm will win its case. A per se prohibition on reverse payment settlements is therefore both overbroad and overly narrow. It will prohibit some settlements that are benign, that are actually pro-competitive and good for innovation and competition, and fail to address other kinds of settlements that lack the reverse payment feature, but also have the feature of the generic firm ceasing to compete as early as it otherwise would. One of the notable facts about the branded generic drug wars of the last decade or so is the players in the market's remarkable adaptability to perceived changes in legal rules. So Scott Hemphill at Columbia, for example, has documented empirically that as courts and agencies in the early 2000s timeframe began to express hostility to reverse payments, the drug companies would simply shift their settlements in ways that no longer entailed these kinds of obvious reverse payments, but still entailed, in some sense, the generic no longer entering the market as early. Let me give you an example of how a smart drug company, and this has actually happened in some cases, could obfuscate or avoid a rule of per se legality for reverse payments and still replicate the monopoly pricing that Michael's concerned about. Suppose that the marginal cost of producing a drug is $1, and the pre-entry monopoly, if you call it overcharge or excess charge, is also $1. So pre-generic entry, the price of the drug is $2. Now along comes the generic firm prepared to enter the market, and the branded firm sues for patent infringement. They settle with the generic agreeing to enter the market immediately as the authorized generic for the branded firm. Guess what the royalty payment's going to be? $1 per drug. So what you'll end up getting is generic competition. Hey, it's great, more competition in the market, immediate entry, and the price will remain identical to the old price, right, which is marginal cost of 1 plus basically monopoly charge of 1 remitted by generic to brand, so the payment seems to go in the ordinary direction, and we seem to have generic competition, but we've actually solved nothing. Believe me, I've spent plenty of time counseling branded drug companies, and they're smart enough to figure out ways around any kind of a prohibition that focuses on the direction in which payment or compensation flows in the settlement. The point is that the social cost of these settlements is not driven by the direction in which the payment flows, but by the fact that there is the cessation of competition between the brand and the generic. So any rule that's going to occupy this space and do more harm than good has to be sensitive not to this question of how the payment flows, which that may be simply one piece of evidence, but really the merits of the branded's infringement lawsuit against the generic and the costs of allowing the delay to happen. So far, I've been focusing only on the social costs of allowing the patent settlements, but of course observe that there are substantial costs of rules that try to restrict patent settlements of various kinds. Let me just tick off a few of those costs. Obviously, we're going to increase direct and indirect litigation costs, both for the branded firm and for the generic firm. We also will extend the period of uncertainty about who can enter and when. Generics usually do not want to enter at risk. And the reason they don't want to enter at risk is because the gains to them from entering at risk are asymmetrical to the losses to the branded firm of them entering, right? If the price falls by about 50%, which is usually what happens when the first generic enters the market, that's a loss to the branded firm that's substantially in excess of the gain to the generic from entering at a more competitive price, and therefore the damages recoverable by the branded firm, if it succeeds in winning the patent case, are much larger than the generic's gains from entering early. So many generics will just stay off the market and not enter at risk. And in many of these patent settlements, one of the features is that the generic's actually allowed to enter the market before the expiration of the patent. So it may very well be the case that on average, these settlements are not delaying settlement generic entry that much at all. Another point is that by increasing the cost of settlements, basically by decreasing the generic's flexibility and options in settling an infringement challenge, you are increasing the cost to the generic of making patent challenges in the first place. Increasing the cost of generic challenges presumably leads to a decline in the number of firms bringing the generic challenges against the brand. And finally, I think most importantly, an obvious point here is that by, again, restricting these settlements, we are decreasing the reward to the branded firm and hence diminishing the incentive to innovate in the first place. And that brings me back full circle to where I began, which is that to the extent that you believe with me that innovation here is the chief objective, that new drugs and new drug applications, not just generic entry, are the chief objective of pharma policy here, then we could see this having an effect on incentives to innovate. Let me just conclude by saying that I think there's actually a lot that Mike and I agree on. I agree with him entirely on this point about the 180-day bottleneck, and that's a very clear change I think that should happen in the Hatch-Waxman Act. But in working through these issues, trade-offs are going to have to be made between potential for long-run innovation and the risks of excessive pricing in the short run. And if in doubt, I'm going to side with Prometheus every time. Thank you.
Well, thank you very much, Dan. I've got a few minutes to respond, and I've got about 7 points. But let me first start just with the analogy of the forest and the trees. Usually when you hear that analogy, there's a difference between the forest and the trees, in which by focusing so much on each individual tree, you miss the forest. Whereas in the example you gave of the forest fire, each individual tree burns down, but it's tough to tell what the good for the entire forest is. And so what I come down to here is that I'm Prometheus, and so I have the tide to prove it. And I'm chained in this cave watching the forest fire. And then the difficulty is that all of the individual trees are burning down because the price of drugs is going up. And there is no real benefit for innovation, as I'll talk about in a few seconds. There's no benefit to innovation for this entire forest. So I'm stuck in the cave watching the forest fire. I can't afford the drugs to begin with because the price is so high. And there are no new drugs to be had at all. And so just to probe into that a little more, we're evil twins, but we're twins nonetheless, and so we agree on a few things. I agree with you that Scott Hemphill writes good stuff, and one gets to this very point of what these paragraph 4 certifications are all about. And so it's possible that my evil twin is exactly right, that all of these drugs that are subject to paragraph 4 certifications are revolutionary drugs on the active ingredient, where all of these little snippy generics are challenging these revolutionary patents. And so by doing that, that really stifles innovation. But what Scott found was that that was not the case, that paragraph 4 challenges apply more to drugs for which the patent is not on the active ingredient, rather it's on the formulation or the particle size or something that's usually less necessary for innovation, that the paragraph 4 certifications also matched up with late filed patents that weren't at the time of approval but seemed to be filed late as a last minute thought, and finally that the paragraph 4 certifications matched up with low quality patents. If you can judge the quality of a patent based on its citation count, the more that a patent is cited, generally the more valuable it is. These were cited less frequently, so were less valuable. So to the extent we have some evidence about what these paragraph 4 certifications are about, I would say that these are not so innovative. So I have 1 minute left and 5 more points. So giving about 10 seconds to each, I'd say that in addition to this, there are numerous patents on each product. And so one example that just recently was in the news was the Cephalon case, in which the court found that the patent here was invalid along multiple grounds. And so it's certainly not the case that all of these patents are valid. In terms of avoiding litigation, sure, you can avoid litigation, but you don't necessarily need this reverse payment. That's what happened. 2000 to 2004, the FTC challenged these things. You had 20 agreements. Not one of them had a reverse payment. Before that time, after that time, loads of reverse payments because the court said it was fine. The direction of payment, I agree with Dan on. It's not the direction of payment that's concerning. Rather, it's the bottleneck. It's something about the 180-day period, the lack of any other challengers, and just one generic being propped up through this regulatory system that leads to the problems. And so that's the concern. And again, the big picture here is that, like my evil twin, I agree that focusing on reverse payments is not necessarily the key for all the reasons that Dan talked about, but rather this 180-day period gives a monopoly, gives a real position to one generic to deal with the brand, and that is the problem here. So at the end of the day, I think the 180 is the problem more than the reverse payment. So I'll close where I began, which is I'm Prometheus. I'm chained to this cave. I'm watching the forest fires around me. I can't even afford the drugs because all these trees are burning, because all these settlements are putting the drugs out of reach, nor are there any new drugs that are coming down the pipeline because those patents have long gone. Now we're just quibbling over these tiny patents that are probably invalid to begin with, and so I'm left watching the forest fire, and there's no benefit to innovation to be found. Thanks.
Mike, and I'm interested in kind of Dan's response to this. Is this the same anti-competitive concern, right? So, I've got someone who has a patent on part of a cellular phone. And he's going around settling with everybody on a very bad patent, right? So he's increasing the cost of that device, let's say, improperly. Is it the same problem there, and then it just becomes a debate again about cost of uncertainty in the patent system to determine validity, which I kind of get a sense that Dan's point is that cost is very high, so we should allow settlement even in those situations? Or is that a different scenario? Mike, what do you think?
So there's certainly overlap in that the power of the patent is an absolute right to exclude, at least as it's asserted in litigation. And so that power of the patent pays dividends for the patentee in both cases, although the context is a little different. So in the troll context, the power of the troll, or the non-practicing entity, if we don't want to drive away the patent folks in the audience, is that there are multiple patents in one product, and so just by virtue of having a patent on one tiny part of that product, assuming you could get an injunction, you could basically hold up the entire product and you could get ransom from the party you're trying to get it from. So it's the power of the patent in relation to the product as a whole. In the Hatch-Waxman context, even though there are more and more patents filed on each individual drug, now there are 3 to 5 patents on each drug, it's not the case that there are so many patents in each product. Rather, it is the bottleneck of the Hatch-Waxman system, in which there's basically a patent and then one generic that can challenge it. And so again, the patent has a lot of power, but it's a bit different in the troll context, one patent or many patents in one product versus the Hatch-Waxman, where that patent really is key, and then you have a regulatory system that only lets a couple people challenge it.
Yeah, I think that the problem in the troll context is the strategic behavior by the troll in waiting until the practicing entity has sort of assembled a suite of patents and assembled a technological path, and then it's very costly to change. And so it's at that point that the troll can sort of extract a much higher price than the sort of fair market value of the patent rights. So I think it is analytically a really different problem than in the pharma context.
So in some ways, so you think maybe settlements, and so this would be, I guess, an interesting kind of Dan's take on it is, then are settlements in those more of a strategic concern or less of a strategic concern, right? So say a lot of people in industry are saying, okay, look, we know this is a bad, which we could say maybe higher possibility of bad patents, but we're still going to settle because of uncertainties, and maybe I'm more concerned because of the kind of hold up effect. Should those be scrutinized more?
Well, I think that the answer there is liability rule treatment for trolls. In other words, I think the remedy under eBay versus Merck Exchange is to treat that kind of strategic behavior not as a reason to lose the patent right altogether, but as a reason to say that the troll cannot assert a property interest and actually block the entire technology portfolio from being commercialized, but instead gets sort of some judicial determination of sort of the fair market value of the royalty rate that they could have charged if there had been open bargaining.
Any other questions?
So, Dan, I'm interested in what we do. Because I'm fairly persuaded that the direction of the payment is at best just a very rough proxy for the validity of the patent. And so, and there are some non-reverse payment settlements that are probably bad from a social value perspective, and there are some reverse payment settlements that are probably good. So I'm interested in, so how do you operationalize that other than just forcing the two parties to not settle and to litigate the whole thing out?
Yeah, so the first thing I absolutely agree with Mike on is that if we were to change the 180-day rule and make it a sort of a first to market and not a first to sort of file, that would have a very good effect in solving a big piece of the problem. But the question you're posing, Jim, is really the question I've been struggling with for 10 years, which is I'm very convinced that I'm right, that the key sort of social cost driver is the ex ante probability that the patentee will win the suit. But of course, that's the very piece of evidence that the settlement deprives us of knowing. So my view is that the FTC needs to invest more. So first of all, the real problem is the private treble damages actions. 8 years later, they're now going back and asking the question like, well, was this settlement pro-competitive or anti-competitive at the time? What would have been the result in the litigation? That's really unwieldy. I think the FTC needs to get in at the outset and make a prospective decision whether or not there is evidence that the patent claim is weak or strong. It's not something they're good at doing, but I don't see an alternative to them actually investing the time as a regulatory matter to deciding that question. And in a case where they conclude that the patent claim is weak, then basically to prospectively disallow the settlement and require litigation, in other cases to allow it.
And I think it really is a difficulty. So we're arguing about these really important issues, and the answer is contained in the black box of whether or not the patent is valid. We can't look in the black box, and maybe it makes sense to let the FTC look at this a little more. Maybe we get some insights. On the other hand, the Federal Circuit years down the road will say the district court was wrong half the time. So how do we really know? And so I think that's really the problem. And that's why for the latter part of the last decade, folks have really fought over reverse payments, because we can't look inside the black box and there's, say, $398 million that changes hands in the Cipro case, and folks say, well, that's a lot of money, so the patent can't be good. But again, it's a proxy, so we don't know for sure. And that's why I keep coming back to the 180, and then it ties into the Trolls point as well. With the 180, you don't really have anyone who's challenging the patent to figure out if it's good or not, because there's only one party that gets 180 days on the market to itself, and that period isn't triggered until that party who's just settled and gotten $100 million enters the market in 2020. And so no one else can challenge, at least in the Troll context and other non-Hatch-Waxman settings. Other parties that think the patent is no good can challenge it. Here, no one else can, because there's only one company that's propped up. And so that's why I think the 180 is the solution here. I know it's pretty nuanced. I know Congress is probably not going to do anything, but that's probably the best hope.
So let me ask you, if we could, we agree, I'm sorry to say we agree on something, but if we actually agree and could change the 180-day provision to make it a first-to-market, would you then back away on per se liability for reverse payments?
Yes, I think that we would not.
Problem solved.
Yeah, exactly. Well, we're done.
You're not supposed to figure it out.
That's not supposed to happen till 1, so at least a little.
Yeah, I think that the whole reverse payment problem would go away if we had the 180-day bottleneck opened up, because then the brand company would be a lot less likely to pay every generic out there, because, I mean, it's possible. Maybe there's a universe of 5 or 10, but on the other hand, you'd always get a smaller company or an Apotex that's going to challenge the brand company and not be bought off, and so I think that's a way around this.
Well, of course, I mean, arguably they'd pay it, just it should be, the payment would be spread over more companies, right? So supposing that their willingness to pay is $100 million to sort of buy another 6 years of no generic competition, they'll just spread it over all the generics that could feasibly file Part 4 certification.
Yeah, although all you need is one of those companies, the small, struggling generic who wants to make it big by filing one of these cases, and not every single one will be bought off, so maybe it's not just dividing it among everyone.
So that everyone can make their 1 o'clock class. Thank you so much, Mike.
Thanks.
Great. Good job. We agree.
Yeah.